May I have the appearances, please?
Morning, Judge. Sue Upper, Leslie Basie, and Zach Wichow appearing for the state.
State your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and I would like to make a reservation of all my rights at this time.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody.
I do not consent to being called that man, for the record.
Mr. Brooks orally moved to dismiss. I'm denying the motion without any further consideration or discussion by the parties. It had to do when he called the state of Wisconsin as a witness for failing to appear and then for failing to state a claim upon which relief can be granted. There's no legal basis for those motions in law or in fact. I'm not asking for any further commentary or statements on the issue.
I object to that ruling, Your Honor.
Present this morning, Your Honor.
I would like a legal finding of fact.
Tonight.
Douglas Kohler, Detective Steve Guth, and Erika Patterson.
I want to state for the record, I intend to appeal that judicial decision made about the motion to dismiss.
All right, let's bring the jury up.
Actually, we did address subject matter jurisdiction. It still has yet to be proven. For the record,
We're going to continue with the witnesses. You have 3 witnesses. The state made arrangements for them to be here. Whatever order you want to call them in is fine, but those 3 are here.
how do you pronounce the name? Collier? I'm still having trouble finding the file for that particular witness.
Mr. Brooks, these are your witnesses. You knew who was going to be called.
I'm not ready to ask that witness questions if I can't even find
I
their
understand.
paperwork.
You not having your paperwork's on you, not anybody else.
So what am I supposed to ask them?
I can't answer
The
that.
witness is just supposed to get up there and I'm just like,
I'm
yeah.
not going to have this commentary. The jury's coming out. Be prepared to call
So
one of the
that's
3.
a rush to judgment.
That is not a rush to judgment.
It is a rush to
Again, I'm
judgment.
done.
It's clearly a rush to judgment if I'm telling you that I don't have the
No,
file.
in my
How am I
opinion,
supposed?
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself? You always trying to pull some fast maneuvers.
Mr. Brooks,
Miss Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
You
still
know
had another one that didn't have nothing to do with nothing we just talked about. It needs to get addressed now because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented by the
I
parties.
can't
The
even
jury
present
will
any evidence. You won't let me even put
disregard.
any evidence in the record. You need to
Everyone
address
can be
the legal
seated.
matter that I was trying to get to before
And
you
you
rush
may call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant. I have to bring
Call
it to
your
your
next
attention.
witness, please. Mr.
I'm
Brooks,
merely seeking
please
to bring
stop.
an issue to your attention.
I'm telling you, I'm asking you to please
And
stop.
I'm asking you,
because
can
we
we
have the
address-
jury present. I will
There
do
was
that
a
at the
legal
next
matter
break.
that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up
I will do
valuable
it at the
time
next break.
afterwards.
Call your next witness, please.
Are you asking me?
I'm directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks.
You swore to protect the Constitution, which you are now not doing.
Mr. Brooks,
So you're
call
going
your
against
next
your
witness,
sworn
please.
oath. If I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. Your Honor, you have to answer this question. You're
Mr.
making a
Brooks.
judicial determination. I informed you that I had some legal issues before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
How can you deny
please.
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out? We do this
Everyone
every day.
is in the courtroom waiting for you. Put it
Things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I
How
will.
can I call a witness and write something down and do
You can
both?
take a minute.
This
I'm
is
not
the
asking
reason
you
why
to-
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury is
doesn't become an
remaining in
issue.
this courtroom. Call your next witness, please.
Are you not a public servant, Your Honor?
Mr. Brooks,
Do I not have your oath? I asked for certified copies that you said on record that you would not provide for no good reason. These are 3 of your
you are
oaths.
doing this,
Right
and I've
here.
repeatedly told you you can see the jury's here.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive.
I'm not going to address
Is
that
this-
at this moment.
Is this not your
and
oath?
I'm not going to
Did
answer
you not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks,
States Constitution?
call
Did you not do
your
that?
witness.
3 times. I have all of them. Here. Your oath, Your Honor. As a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully. Your Honor, I object to that. I want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, interlocutory, declaratory appeal for this matter, and if not, these needs need to be stayed until this matter is before a adjudicated court of competent jurisdiction. I don't even know the true nature and cause of the
Mr.
charges
Brooks,
against
I
me.
understand
I haven't
your
been
request.
provided a complaint. I haven't, Your Honor, there's so many issues.
We
I'm
need
not
to
attempting
continue.
to delay the proceedings
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object
consider
to that, Your
any
Honor.
of what has just happened should not be held against Mr. Brooks in any way.
Your Honor, with everything that I just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing.
Your Honor, I just showed your oath that you swore to took. You
Mr.
did
Brooks,
this, Your Honor.
please call your next witness.
You took these oath of offices. You did, Your Honor, 3 of them.
I understand my
Which
oaths,
is
sir,
very,
very
very
well.
commendable that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but you have to uphold these oaths that
All
you
right,
took,
I'm going to have to
Your Honor.
excuse the jury since Mr. Brooks is
have
not
to-
calling his witness.
You
We'll
have to,
hopefully
you have
bring
to
you back out to
honor these oath of offices as a public servant, Your Honor. I respect you being a public servant. This is not to take a shot at you in any way, but these
Mr.
issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed. They need
I'm
to be.
excusing the jury. Can you please stop?
Your Honor, this is a clear bias.
Mr. Brooks, you are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this
So you're holding
courtroom
me
for
in
the
contempt?
questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, you are
cannot-
refusing
cannot-
to
you
call
cannot-
a witness.
I didn't refuse anything, Your Honor. You can't deny me my Sixth Amendment right, which is
Mr.
to
Brooks,
call
do you want to
witnesses,
be present in
which
this
is to subpoena
courtroom
witnesses.
while you question your first witness? You've consistently talked in front of the jury on issues that are not relevant to their determination.
jury,
Subject
Your Honor.
matter jurisdiction, as you know, is not
As I
something
don't know,
the state
it has
must
to
prove.
be proven. It has to be. And
You are
if it doesn't,
frankly
show me lawful
confusing
law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases with criminal court jurisdiction.
You
That has
don't
been
even
made
have-
abundantly
You don't
clear.
have subject matter jurisdiction or personal jurisdiction.
Mr. Brooks,
Have
I
it proven
excuse
for
the
record.
jury. I'll give you the opportunity to raise whatever issue it was, but you need to do it now. And if you interrupt me one more time, you're going to go do it from the other courtroom because
So
you're
you're
being.
holding me in contempt?
All right, I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings because of your nonstop commentary. What issue do you want to raise?
So are you letting me make an offer of proof of my appeal?
No, but you said
Okay.
you have a legal issue you want to raise.
The legal issue is this. Detective Casey yesterday testified for the second time under oath in reference to my mother's home. He stated that he had been to the home, had seen the backyard, when he did not, in fact, even speak with my mother. It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
because
fine.
she's
That's
willing,
how we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to
away,
be addressed
sir.
because of the issue of the subpoena. That's the reason why I was trying to attempt to
It
bring
could
it
have
to
been
your
done on a
attention.
break.
I would also like to subpoena the phone record so it can be made part of the record. I'm referring
Then-
to a jail phone call that was made last night, and that also brings up the issue of perjury testimony. Will I be
In
able
terms of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
That's what I was trying to gain knowledge of. Can I? Is that
That's
legal for
asking
me to
me
subpoena?
for, I can't direct how you do that. You are acting as your own attorney. You can also call Detective Casey if you want.
I don't think it'd be necessary. You know what he did, and you know what he didn't do.
We're going to bring the jury back out, and then I expect you to call a witness.
I don't have any paperwork for Kohler. I don't know. how to
Douglas
pronounce
Kohler, Stephen Guth, and Erika Patterson.
it. I accept for value in return for value this document.
For the record, Judge, Attorney Wichow just handed to the defendant for his benefit the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it, so let's make that record correct. I can't find it anywhere.
All right, let's bring the jury out.
Good morning, Mr. Is it Kolar?
Kolar.
Kolar. Good morning, Mr. Kolar. November 21st of 2021. Do you recall that evening pretty well?
Fairly well, yes.
Well, let me back up for a minute. First of all, what do you do for a living?
I'm an IT director for a law firm.
Been doing that for a long time?
I've been in IT for over 20 years.
Yeah, that is a long time. Directing your attention back to November 21st. What did you do that day?
I was preparing my daughter to march in the parade with her dance troupe. It was just my daughter and I that went to the parade.
At some point, you observed something happening. Would that be fair to say?
Yes.
Do you recall what that was?
I noticed a vehicle coming where the parade participants were going. A police officer attempted to approach the vehicle, reached for the door handle. At the time of that approach, the vehicle started to speed off.
You heard the vehicle honking its horn.
While it was on White Rock Avenue, it was honking its horn.
And what did you do after you saw the vehicle?
I grabbed my daughter and walked as fast as I could to my car.
Do you recall if the vehicle had any tinted windows?
I believe the rear windows were tinted like most SUVs are.
No further questions at this time.
You did provide a typed statement to the Waukesha Police Department, correct?
Objection leading.
Overruled.
You did provide a written statement to the police department, correct, sir?
Objection leading.
Overruled.
Yes.
You described the SUV as driving erratically.
Objection. Did you testify to that? Asked and answered.
Overruled.
Yes.
When the vehicle was on White Rock, it was honking its horn, correct?
Correct.
There was no objection.
You got a look at the driver of the car, correct?
Objection speculative.
Overruled.
And you described the driver as a black male with visible tattoos.
Objection leading.
Overruled.
Is that consistent with your memory, sir?
Objection speculative.
Overruled.
That is consistent with my memory today.
Once the vehicle went past the officer, you indicated that you saw it accelerate.
Objection leading.
Overruled.
Yes, at that point, sped away.
You may call your next witness.
The defense will call Stephen Guth. Did you make contact with the woman by the name of Erika Patterson?
Yes, I learned that Erika Patterson was the estranged girlfriend of the suspect of this investigation.
You made reference to estranged girlfriend. What do you mean?
I don't know if I should answer that.
Question was pertaining to the word estranged, but we'll move on. Do you know if your partner had any interactions with parties that may have been involved with Ms. Patterson?
Are you specifically referring to a date or just in general?
I think it was clear.
I need
Date
it
would
clear
be-
for the record,
The
though.
date would be
On the
November
21st?
21st.
Okay.
Did you learn at any point that there may have been other parties involved with Ms. Patterson?
In which incident?
I'm referring again to November 21st. And in that interview with Ms. Patterson, what did you learn?
Learned several things. Initially, she was injured by Darrell Brooks on November 20th. They were arguing over the fact that she did not give him money. He injured her by slapping her in the mouth. The next day, on the 21st, she got in a motor vehicle with him. Over the same argument, he proceeded to try to take her phone because he thought she was talking to other guys. Slapped her in the mouth, punched her in the eye. She jumped out of the motor vehicle. There was a confrontation in front of White Rock School with Mr. Brooks. There was some kind of shoving match, and that's when Mr. Brooks got back into the motor vehicle and took off towards Main Street.
You made reference to being told about an incident from Saturday, November 20th. Ms. Patterson stated that didn't happen. Is that correct?
She just stated that she didn't drive around with him, but she also met with him and was slapped in the mouth that day too.
If it pleases the court, I have a document here I would like to show the witness.
All right. You may use the document camera.
Before we go through that process, I'm going to object. It's, well, maybe
Let
we
me
should
see the
talk about
document.
this. Yeah.
And give that back to Mr. Brooks. I'll sustain the objection, or what that document is, I should say.
Sustained on what grounds? You made reference to November 20th. That's what this document is talking about.
It's not relevant to the charges at issue.
Your Honor, I'm going to respectfully object to that and ask for a finding of fact.
It's sustained. Well, their objection sustained, yours is overruled.
Is that noted for the record? I would like a written finding of fact.
The request is denied. Keep going, please.
Denied on what grounds? On what lawful law?
Keep going.
Are you making a judicial determination that you don't have to answer that question as a public servant?
I've ruled on the objection. It's on the record. Please keep going.
Once again, information that needs to be known is being hidden.
Objection. Move to strike all of the comments made by Mr. Brooks in the last 20 seconds or so.
You made reference in your report that Ms. Patterson was not completely forthright. What exactly do you mean by not completely forthright?
She did not give me all the details of the incidents to me initially.
So it'd be fair to say that Miss Patterson had been untruthful.
No, she told me she was extremely afraid of you. And that's why she didn't tell me everything.
In regards to the incidents with Miss Patterson, did you at any time see interviews that were conducted with Nicholas Kirby and Corey Runkle?
What do you mean by see them? They weren't video recorded. I received a summary of what they stated.
Seeing what those two parties had said, what do you recall?
Objection.
Grounds.
Calls for hearsay.
Sustain.
What did you read
Objection.
from those statements given by those two parties?
Calls for hearsay.
Grounds.
Sustain.
Grounds for the sustain.
Calls for hearsay.
No further questions right now at this time.
All right, thank you. Any cross?
No, Your Honor.
Is there only one witness left? No
believe-
one else is here?
No, it's not 10:30 yet.
Who's supposed to come in 10:30, Your Honor?
Call your next witness, please.
Can I be provided that 10:30 list?
I'll write it up for Mr. Brooks to review, Your Honor.
I accept for value in return for value this paperwork. Who determined this order? That's not the witness that was intended to be called at this time.
Please call the witness who's available.
So I'm being rushed to judgment,
No, sir, I'm trying to have an effective and efficient use of all of our time.
which is respected, but at the same time, this is my time
Right, I'm
to
going to
present my
excuse the
defense.
jury for right now. All right, thank you. Be seated. We have almost 45 minutes until 10:30. If you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking a
your
question.
witness.
Is that lawful law?
I have the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of
why
witnesses.
is it always so hard to just say yes or no?
Yes,
Is it lawful
I have
law?
the authority.
I'm not disputing that. I asked the question, is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if you
told
don't
me
want
what
to
you-
recognize it,
you
that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
You told
fine.
me your
Your
authority.
objection
I'm
is
not
noted
I'm
on
not
the
debating
record.
your authority.
I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson.
I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected
But
that.
it's about the rush
You
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
I did not ask them to do that. They
No,
volunteered.
We expect
If
your
they didn't want to do
cooperation in
it,
that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor.
Common courtesy is the stipulation.
Okay,
sir.
but it wasn't
and here's the
stipulated to,
thing.
so I didn't have-
You are well advised of how this process was going to go.
No, I was not. With all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did. in
Did they
that
have to
regard.
do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did not.
I didn't have to be
do it.
provided with, we're going to call this witness at this time,
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you. It's about the witnesses'
It's about what's fair.
availability. No, frankly, sir, it's about you trying to control what's happening in this court.
How? I'm the one shackled to the table with
So here's the
with a
situation.
shock device
It is
on my ankles.
9:52.
So how's I'm trying to control anything?
I'm
I
happy
just
to-
want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to
because
me how
of
that's
the
fair.
process that has been set up to help you. get
No,
the
it's not
witnesses
helping me.
to
It's helping
court.
the state
And no,
by being able to say, if we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later.
I gave them my witness list. It's not my fault they weren't going to be prepared.
If you
I'm just
don't
stating I
call
wanted to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
cooperation, I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided.
That didn't have a time or of
I'm not going to
or an
play
order.
this game with you, sir.
It's not no game. That's
It
what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take
I
this as a
asked
game.
you
That's what
once
nobody,
again.
you don't got to explain nothing to me. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things
unfair
that-
and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is.
And you think that I think this is funny?
I don't think it's funny whatsoever. I
So
understand.
I think, Your Honor, with all due respect, I think you should show
we're
some
gonna take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
Nah,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
Can we address subject matter jurisdiction and still has to be proven for the record?
I decline to do so.
The audio on? Is the audio on?
Yes, it's on, sir. It's on.
So we're not going to address subject matter jurisdiction that has yet to be proven for the record. Have you proven it? Has the prosecution proven it? So that's a judicial determination that you don't have to answer that, Your Honor, being a public servant?
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
Come on, Your Honor. Come on now. You got to cut that out. You have to honor your oath of office. You know that.
The defense may call its next witness, please.
Be it 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment. Defense calls Erika Patterson since I'm being rushed to judgment.
Good morning, Ms. Patterson. If you would please make your way to the witness stand, which is on my right.
I'm trying to find some relevant paperwork here. Just had it on the table. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason. Good morning, Miss Patterson. The evening of November 21st, 2021, what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Objection and grounds for, I object to that and grounds for the objection on behalf of the state.
Mr. Brooks, we did cover many of these topics previously.
Do you recall having any phone interactions when you and your roommate were at the park? Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Let me back that up. Would it be fair to say that during the meetup with the alleged defendant, things got a little chaotic?
Yes.
I want to back up a little bit, if I may, to the day prior, November 20th. Do you recall what you were doing that day? So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes.
Funny. Were you aware that it was reported there was in fact no incident on November 20th?
That's not true.
Objection.
Grounds.
Lack of personal knowledge. Hearsay.
Sustained.
Can I show the witness the same paperwork that I attempted to show?
No.
And why not?
Not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No.
Any reason why it would be reported no incident happened on November 20th?
No objection.
Grounds.
Some facts not in evidence. Sustained.
Grounds for the sustain. Upon speaking to Detective Guth, do you recall why you were not forthright with information?
It wasn't that I was not forthright. I just didn't tell him everything right away.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I just didn't tell him everything at once. I told him the next day, Mr. Brooks.
And in the alleged incident on November 20th, were you injured?
Well, you did hit
Were
me.
you injured?
And having marks on me. Is that what you're asking?
So where were you injured?
Objection. States the evidence.
Grounds. And what were you doing prior to meeting up with the alleged defendant?
Objection.
Grounds.
Asked and answered.
Sustained.
Grounds for the sustain.
Asked and answered.
When?
Next question, please.
When was it answered? You can't recall why an alleged incident on November 20th was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Some facts not in evidence. It's characterized as her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for
question.
a legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied.
Interesting. So it would be fair to say that you have a child in common with the alleged defendant.
Yes.
You have any other children?
Objection.
Grounds.
Has nothing to do with the case.
Not relevant. Sustained.
Grounds for the sustain?
Not relevant.
How's it not relevant?
Next question, please.
How's it not relevant? The child that you have in common with the alleged defendant, do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant. Sustained.
Grounds.
It's not relevant.
She answered it.
Next question, please.
Does that child live with you?
Objection.
Grounds.
Relevance.
Grounds.
Sustained. Not relevant.
Do any of your children live with you?
Objection.
Grounds.
Relevance.
Sustained.
Grounds for the sustain?
Not relevant.
That goes to the credibility, Your Honor, so how is it not relevant?
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Next question.
Is that lawful law?
Next question, please.
I'm getting there. This is lawful law.
Wisconsin State Statute 906.16.
That doesn't answer my question, but okay. In relation to the alleged incident November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. It's not proper procedure, sir.
I'm going to object to those being shown as a witness. They have no relevance whatsoever to this trial.
Yes, they do.
They've also never been disclosed to the state before this moment.
Sustained.
Sustain why?
Not relevant.
They are relevant. It creates foundation.
I'll take up the issue outside the presence of the jury. Next question.
How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Fact, not in evidence.
Grounds.
Sustained. Not relevant.
How is it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence, and
It's
at
facts.
this point,
I got the pictures right here.
after
Facts.
the alleged date of violation here,
Alleged violation. Since the evening of November 21st, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. I'll rise for the jury. I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness. Was the last guy, Guth. The witness was so deeply afraid of me. If you're so deeply afraid, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence?
That's not
Hear me
opening the
out.
door.
Oh, yes, it does.
No, it doesn't.
This witness, Detective Guth, and others, this court has all had to stop them, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. But if you keep questioning her about whether she's afraid or not, or
I
why
didn't
she wouldn't
question her
have
about
contact
that.
or
I
not,
didn't
you are
question her about
opening
that.
the door to that testimony. All of my rulings have been made to prevent prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Over to the state.
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state.
That's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a
no,
misstatement of the
that is
evidence.
true. She said
We're not going to go
essentially-
down a tangent.
All right,
I'm going to
I'm not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
It's not
All right?
fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
I want to see the letter.
I got to bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it.
There are proper procedures, and
Okay,
I want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
question.
I respect your courtroom. I
You
respect you. You're a public servant, though. Your job is to be the referee. You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can be excused. My apologies.
My apologies, too, but it needs to be some truth.
I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. The
And what happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me. The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent to the court regarding count 77. The state sought to dismiss that count, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
It was dismissed because the request was made. They don't need a reason.
Your Honor, I object to that. What does the letter read?
You have the letter.
Yeah, and I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find it.
you're imputing the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? How can you make
You
the assumption
made-
that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may.
If I need to, I'll have a bailiff put on the record that no one touched your table.
I just said I can't find my paper, which is the truth.
And the
I'm
way
looking
that
down.
you said it, like,
don't
well, that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said,
effect.
Your Honor. With
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerk, that would be more validity to what you're saying.
When did you receive this letter?
I received this multiple letters actually over a period of time. It wasn't, I referred to this one because this one had the pictures.
Does it have a date on it? The letter?
No, I didn't bring the letter, I brought the pictures. I thought showing the pictures would be okay. How did I get these? My mind was saying, show the pictures. They didn't come out of thin air. The witness
We need the
knows that
letter.
they sent me the pictures.
Even if she did, what relevance does it have to her credibility?
Because she's put on this facade of being so afraid of someone. You know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing in jail. Oh, this and this and that. Oh,
I don't think
no,
she's ever
still love
said
you.
she was
Oh,
afraid. I
ooh.
think that was the officers who may have stated that. And you asked her why. It was either why did you go back or why did you have, I'll look at my notes.
Why weren't you forthright with all the details? That was the question.
Even if this letter's from her, these pictures are from her, how does it
Your
relate
Honor,
to her credibility?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got, what do you mean signed? No
How
one
do you
signs
know?
letters.
Why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erika Patterson?
Because they were sent from Erika Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was it the content
Are
of
you
the
kidding,
letter?
Your Honor? I'm going to go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. When you
You're
say
not
to
answering
me,
my
when
question.
you say,
Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying,
why
could
was
be anybody
somebody,
else. And it's
Your
called an
Honor,
offer of
this-
proof.
But you still got to understand why this is mind-boggling. I got a child with this woman. Why would I not know her handwriting?
I need to know,
Are you serious?
why do you believe they're from her? I need you to
Because
answer.
they're from her. How else am I supposed to answer that? It has to be put in a legal
The
term
bottom
or
line is,
something.
without that letter, I'm not allowing this line of questioning. Do you have the letter with
So
you?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly.
But if I say something under my breath, everybody seems to hear it.
Yes,
Everybody
we can
assumes-
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic. where
Because
you try to
it's not
go
a tactic,
off of
it's
what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts.
to
Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state-
nobody hears what I say.
I'm going to let the state
man,
make
stop.
a record of why they
Stop.
believe it's objectionable.
Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from him?
No, that you believe.
That I know.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erika Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erika Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erika Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erika Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let
Because
him
at the end
finish.
of the day,
Let
if
him
we
finish,
gonna open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
He's being removed from the courtroom unless he brings that letter
Don't
and he
go
can
sit
show
there and try
it
to
is
think you know what's
inadmissible.
going
She will
on.
not be questioned. I will
Then you gonna
declare
talk
the
about where my
cross-examination
kids live. You don't know where,
closed.
You don't know what
Thank
happened
you.
at the
We're in
time
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
I do have Mr. Brooks in the other courtroom so that I could make an adequate record without interruption. In my almost 11 years on the bench, I've presided over dozens and dozens of cases. To say that this has been the most challenging of my career would be an understatement. I will ask Mr. Brooks for an offer of proof. I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. All right, so we are back on the record. I've been advised that Mr. Brooks does not want to come over to the main courtroom. I see you're reading something. I'm going to ask you whether you are asking to stay in that courtroom. You can hear and see. Mr. Brooks, we are on the record. Would you like to come back here? Yes or no?
Are we supposed to be back on the record?
Yeah. She's asking a question.
Well,
The audio is on.
You're unmuted.
So I'm finally unmuted.
You've been unmuted for a while since I came back on. Record to reflect, he's putting on the headphones.
What's going on?
Mr. Brooks, I'm inviting you back to the courtroom. My understanding from the bailiffs is that you don't want to come back here.
I ain't saying nothing.
Are you ready to come back then?
Not if I'm just going to get held in contempt again.
I didn't hold you in contempt.
Then why am I even over here?
So that I could make a ruling and make a record without an interruption.
Am I ever going to get a chance to make the record without being interrupted?
Do you want to come back into this courtroom?
Not if you're going to hold me in contempt.
So if you don't answer yes or no, and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question.
Are you going to hold me in contempt? I don't want to be held in contempt.
I will ask you again, would you like to come back to this courtroom?
I'm supposed to be in there anyway.
Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not going to hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom.
And for the record, I do not consent to being called that name.
All right, let's take up the issue of the letter and the photographs and your offer of
I
proof.
don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof to
go
provide,
past all
sir?
that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just said
to
no.
the route?
I just said no. I just said that.
All right, thank you. Then based upon there being no offer of proof, then my decision stands. As to the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I'll have to look in here because so much that happens over the past hour and a half or so.
She's already been questioned now twice by you. So what new topics do you intend to question her about?
What do you mean by new topics?
Topics that you haven't already covered.
Pursuant to the police report or something? Is that what you're asking? I don't understand.
I'm asking you what you believe your questioning will be as to Ms. Patterson going forward.
I wanted to ask questions about the police reports.
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here.
Do
Possibly is.
you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson?
No, Your Honor.
How many officers did reports? Because it seemed like it's more than just 2.
May I be able to show me what Mr. Brooks is referring to?
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there. I have to snatch it.
Pages 2 and 3 out of 6 from Detective Barron's report. This is one of the 2 reports we've been talking about.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses.
Your Honor, I just stated 3 times I would have to read a little bit of this to form the questions.
Under my authority, under 906.11, I will declare that his questioning of her to be closed.
Just so I understand what you mean by closed.
You will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
Man, I object to that ruling too. Can you give me a lawful law why?
If you start interrupting me when the jury comes out, you will be removed to the other courtroom.
So I'm being held in contempt again? Might as well have just stayed over there then if I was
Mr.
going to get
Brooks,
held in contempt.
if you're gonna
just take me over
continue-
there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did. That's what that is.
No, that's not contempt.
So is it civil or criminal? Why am I being
Mr.
held in
Brooks?
contempt? That's the whole reason why I didn't want to come over here, because you was going to find a reason to hold me in contempt.
It's not contempt, but I'd find a reason to remove you based upon your disruptive outbursts.
Well, then remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I want
Obviously you
in
do.
this courtroom.
Obviously you do. You brought it up before we can even get to...
All right. Mr. Brooks has forfeited his right to be present in this
How
courtroom.
did I forfeit that right? Why am I being held in contempt now?
I'm not holding you in contempt.
Then what did I do?
You've interrupted repeatedly.
I'm muted.
You are unmuted. The jury is on its way in.
Why didn't we address subject matter jurisdiction?
I'm going to mute you if you do that.
I'm not going to do it when the jury... That's why I asked now before the jury came in.
I already addressed that.
So will it be proven for the record? Will I at least be told why I'm held in contempt when I didn't do nothing? Civil or criminal?
If you can't be quiet, you're going to be muted.
You're going to mute me anyway.
Not if you're quiet.
So I got to be quiet like a little kid?
It's not what I said. You have to be
That's what you
respectful
said.
of the proceedings.
But nobody has to be respectful to me, though. Can I say for the record that 2 of your bailiffs was just making gestures behind my head and made me feel uncomfortable?
Jury's coming in.
So that's not going to be addressed.
Mr. Brooks, I'm muting you. Thank you, everyone. Please be seated. Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. Does the state have any questions for this witness?
I don't have any questions for Ms. Patterson.
All right. Thank you, ma'am. You may step down. All right. The defense may call its next witness, please. Go ahead, sir. You can call your next witness.
So how long am I supposed to stay in here now?
I'm going to excuse the jury. We'll hopefully have you back shortly. Mr. Brooks, I had the jury leave the courtroom. Do you want to come back into this courtroom?
I'm muted. No.
You're not muted. You're unmuted.
So what's going on now? Why am I being held in contempt yet again?
You are welcome to come back into this courtroom.
So why was I removed in the first place then?
Would you like to come back into this courtroom?
You're not finna hold me in contempt no more. Not finna do
I
that.
will ask one more time, and he fails to answer it with a yes or no. I will take that as a no.
You can't answer
Mr.
for
Brooks,
me. You can't do that.
I'm advising you that I will. He's interrupting me once again.
You the one talking right now, so don't do that.
I'm going to
Don't.
mute him because he's not being respectful. He is not reclaimed his right to come back into the courtroom. I'll give him one more opportunity so that it's abundantly clear that I am honoring his right to be present, and I will unmute him.
Don't try to seem like you're trying to honor my rights now because you haven't been doing
he
it.
is, again, not answering the question directly.
Don't try to put on, don't.
I'm going to mute him again. Mr. Brooks, before I unmute you, I will ask you to call your next witness. And if I don't get a direct response, then you will forfeit your right to call any other witnesses.
I'm not calling no witness if I got to be in this other courtroom.
Would you like to come back into this courtroom?
Why was I ever removed? Everything you ask me, you expect me to answer, but then when I ask you questions, you never have to answer anything. I just put on the record that 2 of your bailiffs, they're making gestures behind my head that make me feel uncomfortable. You didn't even address that.
Mr. Brooks, I didn't address it because you keep interrupting me, and then I have to deal with the interruptions and make a record regarding that. So I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question.
You haven't answered my question.
The court's not going to answer questions by the defendant because they're a delay and disruptive tactic. Mr. Brooks,
a delay and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination. If you are in that courtroom and you have not reclaimed the right to be present, you will remain over there. And it looks like he took his headphones off. Mr. Brooks, if you fail to call a witness, you will forfeit your right to present any additional witnesses. I need to know from you right now, you are unmuted. Who is your next witness?
She trying to say something to me? Yeah. What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones? You choose to read.
I'm muted. Why am I going to have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The muting is so that I don't have to hear the disruptions.
Okay, well, then why should I need to hear what
So
you
let
say?
me be clear.
You don't gotta be clear or nothing. I don't got to listen to you.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again? I keep doing this little childish stuff, dude. I got to sit up here and I'm supposed to abide by every single rule, but don't nobody else got to do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks is directly attacking the integrity of this court while yet refusing to answer simple questions. Mr. Brooks,
That's not my name. I told you I don't consent to being called that name.
This is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to present
Can't do
any
that. Show me
additional witnesses.
Show me where that's law. That's all I'm asking. Show me that it's lawful law. How can I forfeit not being able to have a defense? Are you kidding me? With all due respect, I'm tired of having this back and forth with you every day. Regardless to what you may think, that is not my intention. I simply do what I do because I do not have the understanding. I apologize if it makes you feel that I'm intentionally trying to delay the proceedings, because that's not the case. And I feel very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's going to frustrate me. Of course it's going to make me a little bit upset. And I just want you to understand, it seems to me the way I'm interpreting what you're doing is that I'm being held in contempt. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged, one of them is held in contempt.
What's the third, Mr. Brooks?
The third is removed from the courtroom while the trial continues.
That's what's been done.
Okay, so now where does it say after that, having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense? I'm not fully aware of what's going on in the court. Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law. Would you like to come back into this courtroom?
Are you going to kick me out?
Would you like to come back into this courtroom?
Are you going to kick me out?
It's a yes or no question.
The reason why I'm answering like that is because the moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth. It wastes time, really.
I'm well aware of that. It delays the proceedings.
But then it's laid at my feet as if that's my attempt. You think I want to be over here?
I don't know what you want or don't want. I know we need to complete this trial. and that you have frustrated today more than ever before.
I apologize for you feeling that way, but I'm frustrated. Somebody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct.
There is no conduct. I don't understand what you mean by that. I really don't.
Mr. Brooks, I think you know exactly what you're doing. You make cogent and coherent objections. At times, you clearly read, write, and understand English. You waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so.
It's not fair to state, Your
Since
Honor.
I'm not really getting anywhere, I'm going to mute you for the moment. He has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. We are going to continue. So we'll go off the record and he will come back over here.
She wants us to bring you back over there.
Just to say something and then get kicked out.
I don't know what that is.
Yeah, I don't know what to tell her then.
So she's taking a break right now, wants us to have you go back.
No. Because I'm going to end up having to come back over here. Don't y'all get tired of hauling all this stuff over here, over there, over here, over there, over there?
The record should reflect that Mr. Brooks is present in the courtroom in person. The jury will be brought out and you'll be asked to call your next witness.
Being called that name. And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record? So is that a tacit agreement?
I make no such agreements with you.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven? Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out. The defense may call its next witness.
Who's here?
Bertram, Hayes, Aldrich, and Lescano.
What was the last two?
Aldrich and Lescano.
Let's go with Deanna Aldrich. Good afternoon, Miss Aldrich. Well, first of all, let me back up. What do you currently do for a living?
I'm retired.
That's always pretty good. Direct your attention to the evening of November 21. Did you hear anything unusual?
I heard a large thumping noise. When I came out, I saw a red SUV.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
And what did you see from that point?
Someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on.
Do you recall a height?
Probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down?
down, yes.
Okay. Did you at any time observe this individual jump over the hood?
I did not see because I was trying to find my glasses.
So is it fair to say you were trying to locate your glasses so you can get a better look?
Yes.
Do you recall if the SUV had any tinted windows?
I do not.
Before that evening, had you ever noticed that SUV before?
No.
No further questions at this time.
Thank you. Any cross?
No cross, Your Honor.
The defense calls Christopher Bertram.
Go ahead, sir. Your witness.
Oh, I'm sorry. First of all, good afternoon. Directing your attention to the evening of November 21st, 2021. Do you recall that evening pretty well?
Not very.
At the time you observed this smashed up car, as you say, were you able to make a description of who was driving? What do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
Do you recall if the law enforcement officer was writing down what you were telling them or recording it?
I don't recall.
Do you recall stating that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Do you recall what the operator of the vehicle was wearing?
I do not remember.
Do you recall stating that the operator was wearing a black sweater or jacket? Do you recall saying that?
No.
Do you recall seeing the vehicle crash into anything?
No.
Do you recall around what time you called 911?
No.
Do you recall shortly after seeing this vehicle texting anyone? What did you tell her?
I don't remember.
But you do recall seeing the operator wearing a black sweater?
I don't remember.
Did you observe seeing someone run from the vehicle?
No.
Do you recall why you would have gave a description that evening?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds?
His answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross?
No.
When we get to the next break, I have something to discuss outside of the presence of the jury. If that pleases the court.
Do you want to do that now? Or?
I can.
All right, I'll address a legal issue, and we'll bring the jury back in when we're ready.
I'm curious, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
To be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or fact.
It's obvious. It's clear.
You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is, how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
For the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We're just going to let these people go.
Well, this is
And I-
argument,
Come on, man. I
sir.
see
It
through
is pure
I just want
commentary's
that on the
point.
record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in
Yeah,
fact.
I know that's what's being done.
You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and you're
I'm far-
not.
I'm far from an idiot.
They're your witnesses, sir.
So I'm going to start asking every witness up here that they seem just to mysteriously now not have any cross for, have they been coached to answer the way they answer? Because
Well, you can't ask that, but you can ask them if they've met with anyone ahead of their testimony here today, which you've done with other witnesses.
I find it very funny that these are their reports, and now all of a sudden, oh, I saw the person in the car. Oh, but I
This
saw
is
them
an
reach
attempt
for something.
by you
Oh,
to
I don't.
delay these
I don't recall
proceedings.
what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on.
I'm having the jury brought out. I'm instructing you to
Come on, man.
avoid the commentary. You will
I didn't
forfeit
say-
your right to be
I didn't
present.
say nothing.
Before we do that, there's an issue that we do need to pick up as to a witness. He has prior criminal history.
Thank you.
I would like to provide the defendant and the court with a copy.
So that had to be said. The defendant.
That's not how it was said. I
That was how I
completely
said. You want to
disagree.
run the record back? I
Mr.
got
Brooks,
one ear that work, and I heard that.
This
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom, and I have to elevate my voice.
So she had to
Alleged
elevate her
record
voice
of Abel
just for
Lescott.
that.
Stop talking.
Like, I don't know who y'all be thinking y'all fooling. I accept for value, return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can
believe
you
he
please-
has 7 prior criminal convictions via OWI 2nd from 1997 and OWI 4th from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break. I'd like to continue by bringing the jury out. Who's your next witness?
May I ask who's present right now?
Mr. Hayes and Mr. Lescano.
Subject matter jurisdiction, Your Honor.
The court declines to address that.
Still has yet to be verified and proven for the record.
Do you want Mr. Lescano on the stand, or are you going to call Mr. Hayes?
Can't find paperwork from Mr. Hayes. Can a police report or something be provided?
Yes, we will accommodate that request.
All right, then, let's have the jury brought out.
Defense calls Jason Hayes. Jason. I accept for value and return for value this document for the record. Good afternoon, Mr. Hayes. What do you do for a living?
I'm a retail sales associate for a food broker.
Been doing that for a long time?
21 years.
Yes, it's a long time. November 21st, 2021. What were you doing that evening?
Went to the parade.
Were you scheduled to do any marching in the parade
No.
or just spectating? Anything unusual catch your eye that day? What did you see?
Besides the parade,
Yeah, I'm sorry.
well, where we were, a red truck came through. It honked and swerved.
I want to back up. Why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
You stated that the vehicle honked.
Was that just a single honk, or was it a beep beep, or?
One honk.
Did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main, the same route to the parade.
Did you get a license plate?
I did not.
No further questions?
Do you remember writing in your report that a police officer chased the vehicle on foot?
Objection, leading.
Overruled.
Do you remember also telling the same officer that the SUV took off and that it accelerated?
Yes.
Objection. I guess the objection to be what officer is being referred to.
Overruled.
I was asking, was that referring to the interview officer?
It's overruled.
Is that your recollection, sir, that the vehicle sped off and accelerated?
Yes.
Objection, speculative.
Overruled.
But you didn't see a face, you couldn't
No.
identify anybody?
It's overruled.
Who's supposed to be arriving at 3:30?
Babietz and Darrell will be here at 3:30. Mr. Liscano is here now.
I knew he was here now. Just trying to get clarity.
Are you going to call Mr. Liscano?
It would appear so. He's the one that's here.
All right. Then
Good afternoon, Mr. Liscano. What do you do for a living?
I'm a hairdresser.
November 21st, 2021. What were you doing that evening?
The Christmas parade?
Were you marching in the parade, or
No, I was watching it.
you recall something other than the parade catching your attention?
People getting hurt, yeah.
And what did you see?
I saw a red SUV plow over a bunch of people.
Did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
You recall stating that it appeared that there were 3 or 4 people in the Ford Escape as it passed you.
No, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
You said you saw the SUV strike some people in the parade. Do you remember what group? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
overruled.
No,
Speculative. Objection.
Overruled.
Do you remember seeing the SUV strike more than one person?
yeah.
Objection. Speculative.
Overruled.
About how many people did you see the SUV strike, sir?
Objection. Speculative.
Overruled.
Just kept swerving and was just plowing everybody out of the way.
We're going to put up State's Exhibit 65.
Objection.
Overruled.
Do you recognize the area on the screen?
Yeah, I believe that's Central Middle School, right where the stairs is.
The red brick on the left side of the picture?
Yeah.
Objection.
Okay.
Speculative.
Overruled.
And would you agree with me the house where the SUV was found was up in this area here where I just put the green dot?
Yeah.
Objection. Leading.
Overruled.
That looks right, correct, sir?
Objection. Leading.
Overruled.
Objection to the relevancy of this video to this particular witness.
Overruled.
Overruled on what grounds, Your Honor? Is that attack an agreement?
Sir, did you see yourself or your family in that clip?
Objection. Speculative.
Overruled.
No, I did not.
You saw 2 or 3 black males standing near the car, right?
Objection. Mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection. Stated it was black males. Asked and answered.
Overruled.
Do you happen to know the people that live at this house?
Objection. Speculative.
Overruled.
No, I did not.
Is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
There was a lot of people running around in the area, is that correct?
Objection. Mischaracterization of testimony.
Overruled.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection. Speculative.
Overruled.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Okay. You see that driver present in this courtroom here?
Objection. Speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection. Speculative.
Overruled.
You said
And
that...
mischaracterizes the testimony.
Overruled.
Mr. Liscano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right?
Objection. Hearsay.
Overruled.
Mr. Witchow on the end, did you ever talk to him?
Objection. Hearsay.
Overruled.
No,
Any redirect?
Yep. Did you see what the driver was wearing?
no, I don't remember that. I saw the side, you were flying fast down that street.
Do you recall how long you were able to get a side view, as you called it, of the alleged driver?
No, it had to be a couple seconds.
In a couple seconds' time, you were able to make out the driver's profile and race.
Yeah.
You stated to both law enforcement officers that you observed 3 or 4 people in the SUV.
The reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
Any reason why both detectives stated that you observed 3 or 4 people in the SUV at
the time of the parade?
So what's your question?
The question is, why did you report that?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's the only reason I said that.
Go ahead. Call your next witness.
Kathleen, good afternoon, Miss Uriel. Is it Uriel?
Darrell.
Uriel. November 21st, 2021. You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while. Can we pull up the exhibit? I believe it's 15. Can you point out exactly where you were positioned? Do you recall if there were barricades?
I can't honestly recall.
We can take exhibit 15. Did you see anything that may have alerted your attention?
Yes, a car coming through where the parade was starting, and I was thinking it was going to leave the parade rail, continued on into the parade.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn?
Yep, the horn was beeping.
Do you recall if you might have seen multiple people in the vehicle?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while. Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily clipped me or the two people that were in front of me.
Were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection, leading witness.
Overruled.
I can't be too sure.
Overruled.
You were standing here, is that right?
Correct.
Objection, already answered that, asked and answered.
Overruled.
You walked in this direction, is that correct?
Objection,
Correct.
leading and speculative.
Overruled as to both.
How many children do you have, Miss Uriel?
Objection, irrelevant.
Overruled.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection, leading.
Overruled.
Your oldest daughter, Charlotte, she was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection. It's overruled.
I didn't even state why I was objecting, but okay. We still need 15.
You didn't see your kids get hit, did you?
I did
Objection, leading.
Overruled.
Objection, hearsay.
Overruled.
Did you see them later that night?
Objection, leading.
Overruled.
You were directly involved in their medical care in the days after the parade?
Objection, leading.
Overruled.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
not. She did.
Objection, leading.
Overruled.
Vivian suffered a severe concussion, didn't she?
Objection, leading.
Overruled.
Grayson, he was 8 on November 21st, is that correct?
That is
Objection,
correct.
leading.
Overruled.
He suffered a compound fracture in his femur, is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection, hearsay. I don't believe he's a doctor.
Overruled.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound, is that correct?
Yes.
I don't have any other questions.
Will you redirect?
No redirect.
Thank you, ma'am. You may step down.
So we're going to take down these exhibitors. They're going to stay up on there.
We'll take it down.
Good afternoon, Miss Babias.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
November 21st, 2021. Did anything catch your eye that evening? Back up. Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes. The driver looked like through me.
What do you mean through you?
I feel that it is very hard to explain that look, but it was very frightening.
Were you able to make out a license plate number?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
At what point were you not able to see the SUV once it passed you?
Once it went into a bunch of people.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You spoke with FBI agents, reported no injuries.
They didn't ask me about injuries.
Would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh. But you didn't report this at any time whatsoever?
Has to answer an objection.
Grounds.
Sustained.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds. Did you file any claims related to the incident?
No, I did not.
Did you had any interaction of any kind with any of those 3 district attorneys?
I have not.
Just for the record, when you asked that, Attorney Basie was just pointing to herself.
What would be the reason for that?
Since there's 2 tables of individuals, I think she wanted to make the witness aware.
Working in law enforcement, sure this isn't your first time being involved in a trial. Have you ever testified in any way before today?
Objection relevance.
Grounds.
Overruled, you may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and a district attorney would sit in a courtroom, correct?
I know where they're sitting, yes.
I want to back up a little bit. Observing the vehicle approaching your position, did it appear the vehicle attempted to strike anyone?
Yes.
And why would you come to that conclusion?
Because I saw an officer have to jump out of the way in order for the...
When it was approaching.
When it was
approaching.
I'm confused.
Hold on. Go ahead and answer the question.
So I saw an officer attempting to stop Mr. Brooks from driving through the parade. At the last minute, jumped out of the way. Otherwise, he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed for the last question that you needed to?
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You stated that you received your subpoena in July. Now you said last week.
Those are both correct.
You received 2 separate subpoenas? What was the difference between the 2?
One was from the district attorney's office and one was from you.
The one that you received from the district attorney's office didn't have a case caption on it?
What's a case caption?
Just 1 second. 1 second, Your Honor. If I may
just
ask.
object to this line of questioning. I really don't know what the relevance is.
There's no objection at first.
But there's no.
I'm going to sustain the objection.
When you were subpoenaed in July, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds. Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office?
Objection. Relevance.
Grounds.
Sustained.
Grounds for the sustained.
Not relevant.
What? Mind-boggling. In July, when you received your subpoenas, were you even aware of what you were being subpoenaed for?
Objection. Relevance.
Grounds.
Sustained. Not relevant.
She's testifying in the trial and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena. Please ask the witness a
This is
relevant and probative question.
This is mind-boggling. Mind-boggling.
Remind the jury that the statements of the parties are not evidence.
Gotta go through those field. Did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for sustained. I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr. Brooks,
I think
I'm
that's very
sustaining the
relevant.
objection, asking you to move on.
Y'all, this ridiculous, man. Seems to me like a lot of your answers are coached. Is that fair to say?
No.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued before.
Grounds.
Asked and answered.
That was not asked nor answered.
Please ask a question.
Man, what is y'all people trying to pull, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination to be ended.
It's not an examination, it's direct.
It's a direct examination. Under 906.11, you are directed to ask a question, or I will ask the state if they have any questions.
I heard you.
Thank you. Next question, please.
You know who the plaintiff is in this matter? Who's the plaintiff?
The state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Relevance.
Sustained.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague. Ever had any interaction with the state of Wisconsin?
Do not answer that question.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
I directed the witness not to answer that irrelevant question. Mr. Brooks, ask your next question.
I'm going to get to it.
Thank you.
So when did you first report your alleged injury?
You do not have to answer that question.
Grounds for
906.11, sub 1, sub A, sub B, and sub C.
Is that lawful law?
All right, you may sit down. Does the state have any questions for this witness?
Were there with 2 kids? What were their ages on that date?
Objection.
3
relevance.
and
Overruled.
Of course it's going to be overruled.
3 and 6.
Mr. Brooks, sit down. I'm asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. I'm not doing anything wrong. I'm merely standing here.
Approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination.
The state can ask the same question I asked. So how
Go
come when
ahead.
I did that, it was
Overrule, the witness may
it was
answer.
sustained?
Could a car have gone down Pleasant Street?
Yes.
Objection.
Overruled,
Hearsay.
the witness may answer. It's not hearsay.
So when the red SUV turned, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
That's hearsay. She's speaking as a
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is overruled. The witness
As
may
usual.
answer.
It's always overruled.
Sorry, there's a lot of talking.
You and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. Mischaracterization of what was testified to.
Overruled.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Because she is a first-hand eyewitness.
No, I'm talking about you.
It's overruled.
You saw a police officer have some contact with the red SUV. Do you recall that?
There was a few times that police officers attempted to stop the red SUV.
Let me read the report.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
I don't know why that wasn't put in the report.
Do you recall if you told the FBI agent?
I believe so, but it's been a year.
I'm assuming that means that there's some details you don't quite recall all the way.
Yes.
If there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening?
No.
So what other details do you not recall?
You're under. How does someone recall the details that they don't recall?
Yeah, that's what I wanted.
Sustained is to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recall.
Objection. Badgering the witness.
Yes, sustained. You are warned. You may not badger or argue with this witness. Next question.
Badger or argue? What do you mean?
Next question.
What do you mean?
Don't intimidate the witness.
Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering.
But you said
Mr. Brooks, I made my ruling under 906.11. Please ask a question.
How did I intimidate?
Under 906.11, sub 1, sub A, sub B, and sub C, ask your next question, or the questioning of this witness will end.
How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the 62Q trust, right? That you want to be the beneficiary of?
Please do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law and understanding the issues presented. Do not investigate this case on your own or visit.
You even gonna call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None. None.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods.
No, we haven't received anything, Your Honor. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that. If I want her to be here, she gonna be here. It ain't even got to be no arrangement. All I got to say is come. She gonna come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her here at 9 a.m.
We said all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a judge?
Mr. Brooks, I need to make a record of some
I need to make a record too.
You don't.
When am I going to get the chance to do that?
He's being removed to the other courtroom. He is yelling at me. He hasn't sat down for the better part of 2 hours. I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I need him to go to the other courtroom because I do need to put some things on the record. The record should reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what is
I will make the record when we get back. I will step off, but Mr. Brooks, you're being taken to the next courtroom.
Mr. Brooks. Don't try to address me like that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
Record to reflect that Mr. Brooks is in the adjacent courtroom. He, I think, had been standing for the better part of the last couple of hours. He was very argumentative with that witness who, again, he called and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures. And again, I'd remind everyone it was his witness.
So for the record, I think it's important to note that the two photographs the defendant attempted to show depicted the defendant and Miss Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I'll make an offer of proof that Miss Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who in turn provided them to Dawn Woods. That was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks at any point between his being taken into custody and today. He has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks.
and I wasn't really hearing everything that was just said good. I did hear a reference to what was he just talking about? Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got, like, you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up, be biased, be prejudiced, 4 against 1. Why was the statement of particulars not addressed? Have yet to show that you even have a license to practice law, and neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair. When the jury was selected, I struck the whole jury. So how can you go over that constitutional right, which I have the right to not pass a jury?
Mr. Brooks, I'm muting you. He is simply rehashing previous determinations of this court. Issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. Thank you, everyone. We are in recess.